talking till it's dark out somehow. Can get you off my mind. Don't wanna say goodbye, bye, bye, bye. Maybe we should take it slow. I don't feel too comfortable jumping into something new right now. Yeah, I don't really know anymore how to feel something again. Think I'm just scared of falling. Don't wanna go all in. I don't really know anymore how to be more than your friend. Think I'm just scared of falling. Don't wanna go all in. Early mornings in your dome, I'll be sneaking at the door while the sun rises. Cause I ain't got the time, yeah. Keep telling another lie. And baby, I know you want more than this, but you know I can't afford your kiss. So I'm staying for the night, but then I gotta say goodbye, bye, bye. Maybe we should take it slow. I don't feel too comfortable jumping into something new right now. I don't really know anymore how to feel something again. Think I'm just scared of falling. Don't wanna go all in. I don't really know anymore how to be more than your friend. Think I'm just scared of falling. Don't wanna go all in. But baby, I don't know. I think I'm scared of falling, and I really don't know how to feel. Yeah. I don't really know anymore how to feel something again. Think I'm just scared of falling. Don't wanna go all in. I don't really know anymore how to be more than your friend. Think I'm just scared of falling. Don't wanna go all in. Why are you going back and forth? I can't keep up with your routine. What is troubling your mind? Are you doing this just to test me? I'm bad at handling this type of thing. I don't get it. You say it's a man thing. Babe, I wanna be around. I just wanna
We back at it. Mm. Mic check, mic check, mic check. Mic is good, y'all. Hello, ladies. It's just us, so that means we could really be bad. What up, y'all? What up, y'all? What up? What up? What up? I'm gonna start this one here off with this story that just kind of dropped at 4:48 this afternoon, right? And one thing I've learned about us people. Hey Harlem Beauty, what up Sheila, what up Galatians, Demetra, what up, what up, what up ladies, hello, hello. We're gonna try not to be too long, y'all, cause I gotta go to sleep. But this one story about this R. Kelly's attorney, I guess it's Nicole. I'm just gonna read the article to you guys. It's Twizzler's night. Girl, I ain't had one in a while either. So I think since the last time I've been on, it's been a while because they've been, if I put them out of sight, then they out of mind. What up, Tanea? What up, Tanea? Hello, hello. We gotta get Jet Fly Leap back in here, y'all, so we can laugh a little bit on his goddamn story. So I'm watching my cursors. Let me fix this here shit. I'm gonna probably tear it down any damn way. But yeah, we'll laugh on his stuff. We might as well. This stuff here, it's all out of whack anyway. It's all out of whack anyway. And damn if you do, damn if you don't. It is, damn if you do, damn if you don't, right? But it's good evening or almost good night out there, right? Almost good night. What up, what up, what up? Who is Adrena? Is that how you pronounce your name? Maj, y'all want to welcome Adrena. Hello. I hope you hit the like button on your way in and sit back and enjoy. This is just a shits and giggle. We're just going to be going over just a few things and talking a little bit of crap tonight. I haven't seen the ladies since a couple of nights before my birthday. And then they had a sneak peek of the birthday. And so I'm just dropping in on them and getting back into the groove because I took some me time, Adrena. I took some me time for my birthday week to celebrate me. It was about me. And I did that. So now I'm back. But we are glad to have you here. I hope that you stick around in a little bit of time and join the membership over here. We got a little bit small, unless you get into some type of beefs or something out there. Then it'll get a little bit big in here. But these are females that you see in here. They've been rocking for quite a long time. 2 years now. 2 years, yeah. So, and most of them have been here for that 2-year duration, and I think that they're planning on roughing it out with me over here. So I am glad that you took the opportunity to come over and see what we're all about over here. So it's nice to meet you. Good to see you. So 38 is in the chat, you guys. Come on, let's get the likes up out there, only because you get to see my smiley face tonight. My smiley face, that's all. Even y'all sitting in the bushes. Even y'all sitting in the bushes, go on and hit the damn like button. It ain't gonna hurt you, like everybody else says out there. It ain't gonna hurt you. But right now, there's a hot topic out. There's a hot topic out. Hot topic, right? That hit the stream out here. Let me see if my baby, you in the house? Okay. I only be a little bit. So as soon as I can get this stuff, because I'm jumping on here mighty fast. Mighty fast. Let me get that right. But yeah, so 4:40. Let me get the exact time that Mesner. This guy here, he's journalist from the Chicago Sun-Times. Everybody knows about Chicago, right? Chicago Tribune, my bad. Chicago Tribune, right? I'm not sure how long he's been a journalist for them. That I will try to look up for you guys. And before I left off the stream earlier, Nez Never Trust, I had made a comment about the people that do journalism for Chicago Tribune. Some of them are probably, freelancers. I don't know, and just go up. And I don't know how journalism actually work when they're working for a news company, per se. Oh, I gotta take this off, y'all. I'm trying to get comfortable. Gee, but they cricket. Comfortable like y'all, because I know y'all at home comfortable, right? Should have brought some popcorn to the screen, but yeah, I don't know. I'm waiting on uh unbiased and biased article, like I said, about Jim Derogatis. I don't know if that would be an ethical thing to do because, to my understanding, I believe that he, at one point, Jim Derogatis, that is, came out and spoke about that him and there's another guy, so actually a female. Hey, Jeff, there's a female, right, that goes by the name of Brett or something, who actually, according to the article, broke the too cute. What up, girl? What up? Who broke the story about the alleged sex tape and everything, and Sparkle and all of that, right? According to the article, a lady named Brett actually broke the story to Jim Derogatis, right? And then Jim Derogatis actually kind of just, rolled with the story. The story got a little cold for him because of the alleged first female that had these allegations, I guess, did not want to speak out. And with my opinion on it, I believe that she didn't speak out at that time. It was because there was some money transactions that was possibly already done with that Susie Logan attorney downtown Chicago. So that was some back in the 90s, 94 or somewhere. So you guys pretty much know who I'm talking about. Goes by the last name of, I believe, Hawkins or something like that. Okay. So it was a lady named Brett who worked for the Chicago Tribune. I'm not sure if Brett, Brett, is still employed in doing journalism. I have to kind of look that up to see if there's other articles that she may be writing on, but she the one started all of these allegations about Mr. Robert Sylvester Kelly, and kind of brought it to Jim Derogatis' interest out there, and he kind of rolled with it for all of those years. Then it kind of went cold and everything until the Me Too and the Mute R. Kelly campaign started to get loud for the advocating for the women rights out here that is allegedly being abused or assaulted or held in a coat and all of that type of stuff, right? Black women rights or something. Black girls matter. That's it. Black girls matter. So Jim Derogatis again continued up his hunt on Mr. Robert Sylvester Kelly through his duration of being able to journalize while he is also teaching or doing some other curriculum activities for his life. He also stated that during the time where he was doing the investigation and note taking and gathering information on Mr. Robert Sylvester Kelly, that it had cost him his marriage as well. Okay, never trust. That's good. So, but yeah, that's what he claims, that, he endured a lot of heartaches throughout the investigation of Mr. Robert Sylvester Kelly. So then after that, he made notes about Mr. Robert Sylvester Kelly finally recognizing, who is this guy that is on my coattail for 25 years? And we all know that he put that in his I Admit song, right? So we all have heard that, right? But yeah, that's kind of where Jim Derogatis picked the story up, dropped in his lap from a female named Brett. that also worked for the Chicago Tribune. Well, I've been noticing lately, even on Twitter, that you now have this Jason Mesner, right? That is usually on there quite a bit, dropping all kind of information, whether if it's about Mr. Robert Sylvester Kelly or some other particular important person or who he thinks is important for people to know through his news aspect of his journalism. Okay, so that's what he does. Like I say, the only thing that I see him pretty much dropping out here, I don't want to say like it's bad news, but it's news, but I just look at him a little bit differently, right? I also look at him a little bit differently because as he drops his news, it's like, okay, I wonder who does he have association with out here and things like that. I do notice that people do converse with him on Twitter, and he does converse back on some certain topics that he may put out. But let me read you guys his article that he dropped on at 4:48. And one thing about what's going on here in the sector over here of a lot of people that is supporting Mr. Robert Sylvester Kelly team is that people will jump on it quite quickly out here before it kind of, form like concrete. It's like if it's just poured, it's just not quite ready, and I get it. You got to throw it out here in the air and everybody's like, ooh, oh my God, oh my God, I'm just gonna read the article to you guys, and I'm not gonna speculate on, right now of what's gonna happen and what's not gonna happen because I don't know, and I can't tell you that. Bookham said she was gone, and then someone came in the chat. Then he changed his mind and said that, okay, well, I guess she's not gone. And that's what I mean. It's like you don't, with this particular case here, you really just want to be careful with the way you spew things out. If the concrete is just still wet, it's like sometimes you just really have to hold off on speaking on some things until it has formed and you got the correct information to put out here. Me, I'm going to wait until I can see it on national TV, just like they have done pretty much all of the news out here. And 9 times out of 10, when you have more than one news channel running it, it's going to be a little bit truth to it. It's up to you. But let's do this article right quick. How's everybody doing in the chat? And I am so glad that you are here and taking the time to spend just a few minutes with Juan Papoose over here. So I appreciate that. A key attorney for the indicted singer R. Kelly has abruptly asked to withdraw from the federal case against him in New York, potentially throwing his legal team into further disarray just a week before jury selection is set to begin. So when I read that earlier, and after jumping on another screen channel earlier, and I was like, oh, wow. Oh, okay. Well, the first thing that I thought that I would do would be, I'll go to Pacer. Let me see what it is notating on there. At that time that I went, there was nothing there like it was with Greenberg and Tom, right? It was there. It was there in the Pacer that this was submitted to the court for these attorneys to be withdrawn. But of course, everybody come out and started saying that no, that they were terminated. I believe some of the articles was changed out there too. I believe coming across a few articles where it did say that R. Kelly had terminated his previous attorneys. Well, as of today, I didn't see anything on Pacer, and I have to wait until it drops on Pacer. I am not listening to anybody else speculation and allegations that they chooses to kind of put on the screen when I can click on it and read it for myself. So it says here that Nicole Blank Becker, who took over the case in June after Kelly said he wanted to part ways with his two Chicago-based attorneys, filed her motion to withdraw last week. So, according to Jason Mesnier, the allegations is that Nicole has put in her motion now to withdraw sometime last week to exit from off of the case. Mm-hmm. Well, he'll still have 3, right? Okay, 3 is better than none, according to the court record. So somehow, hey, PDQ, somehow Mesnier is able to, I guess, converse with certain people and find out all of this information before everybody else. So there you have it. According to the court records and the sources who spoke to the Tribune about the matter, it ain't nobody out here that can hold water. These people know they be calling and telling everybody, tell it. They be telling it. Says over the weekend, an order from the U.S. District Judge Ann Donnelly appeared briefly on the public docket, giving Becker until 5 p.m. Monday to submit a letter. This is where you, if you were over on the Bookham show, heard him screaming that, nope, she's gone. It's after 5 o'clock. So I believe that this is where he got his assumptions from until someone commented in his chat that, no, they said wait until tomorrow. So then he recanted what he had to say about Nicole exiting Mr. Robert Sylvester Kelly's case. So the submission was to be made expert tape, meaning prosecutors would not get to see it. Oh, okay. I didn't know what that meant. X. And we know X means out. So the prosecutors are elected out of them. They are exempt. They can't see it. Boom, they didn't want them to see it, which I don't know why. That's weird. The reason for her requests are unclear, and it is not known whether the judge will grant it. The motion is expected to be discussed Tuesday at Kelly's final pretrial conference in the U.S. District Court in Brooklyn. Contacted by phone Monday, Becker had declined to comment on the situation. Well, if she declined to, oh, thank you, Jessica, thank you. If she declined to comment on the situation, I want to know who was it that she told that contacted this source called Jason Mesnier. The things that make you go, you don't want to have a comment on it, but you obviously had a conversation with somebody that contacted the source that dropped this information. Does it make sense, you guys? Does it make sense? And I'm not throwing no shade, I'm not throwing no shade or nothing to Mr. Kelly's attorneys, but I'm just telling you that it don't make sense. You don't want to comment, then that means don't even talk to nobody. Just nobody to put your paperwork in. It's between you and then you're waiting on the judge to respond to give you an answer or what to do. Then once you're gone, if you want to come out and talk to the news about it, and then that would be a different thing. But no, somebody had a conversation about this, and went to the source, and the source dropped this information. Exactly. You say it was also in the Chicago, or it was in the, because this is from the Chicago Tribune. This is his article. So the development comes as Becker and her co-attorneys hit back on a request by federal prosecutors to admit new evidence of the sexual abuse at trial. Saying in a court filing over the weekend, they were blindsided and have no time to prepare an adequate defense. But it also says as well in this new documents that these are what do they call it, uncharges. These were not further allegations of what he was being charged with. They was just throwing more details in it. So, but I get it by her saying that, okay, we're blindsided and have no time to prepare an adequate defense. I gotta make an argument. I gotta play devil's advocate right now, you guys. I do, because I just do. And Nicole was there with Greenberg now. I saw her coming in and out of the court, right? We also know that there was a motion put in for Greenberg to that was asking for a lot of the disclosures, right? A lot of the discoveries. I'm sorry, a lot of the discoveries, right? And the prosecutors was hesitant, and they just wasn't turning over quite a bit of things. And then I started hearing a lot of people out here, you know, and Nicole is this, and Nicole is going to be no. Nicole's good. She's got it. She's got this things. You know, she's used to be a prosecutor. She knows how to do it. And I do believe in, and to assure myself, I understand what it's like of having your hands tied by a boss. So, because I believe that since she's working up underneath Greenberg and them at that time, that was, you know, her boss. That was her boss people, counterparts, whatever. But he was the lead attorney in Mr. Robert Sylvester Cummings' case, right? So, but it's like, I mean, at one point, I guess I would have liked to know that there was an argument between, I'm not talking about like a physical argument, like just a more in-depth conversation between the counterpartners who was working together, and everybody saying that she, you know, she's this hardball, she's, you know, she's this and she's that, right? And I was like, well, I can't understand why there was not a bigger fuss to Greenberg to say, well, you know what? Hey, we got to get more emotions in. We got to do so and so. We got to do this. We got to do that. We need this paperwork. We need this. We need that. We can't do this. We can't do that. Right. And I guess I would rather have heard those arguments, you guys. Like, this is bizarre. You know, here is claiming that because of the new detailed paperwork that has dropped out, that she felt that they're blindsided and that they would have no time to prepare an adequate case. I like to see what some of you guys think about that right now. I do. You know, desperate times is desperate measures, right? Yeah. Her, she wants out. Is it her or her? It's her. I'm on the right side. Yeah. Nicole Beck, allegedly. So tomorrow, I guess that everybody can be prepared to find out the truth of what is being said with Jason's Mezzanier from Chicago Tribune. Yeah, 1 second. Sorry, guys. You know what? I keep saying, do not answer this phone when I'm doing my live. I'm gonna have to put it on do not disturb though. So, but I'm back. Hello, Charger. Hello, Lady Diva. Whack the hell. You say whack the hell out. Get back with me once I slip. You say you don't ever. So you think you say you lost on it, Beauty. What do you think, Harlem? What do you think about that? I don't know. Good evening, everybody. Hey, Brenda. What up? I hope I haven't missed anybody, but we're just in here trying to shout out to all the ladies in the green. That's what's up. Hello, ladies. Every day, Gemini, when you sneak in here, I didn't see you. But welcome, everybody. So, what are you guys thinking? Like, I don't know. Did I give it any thought when I heard it? Nah, because I'm sitting back. I'm like, well, okay. That's another one down. He got three more to go. It's still a fight. It's still a fight. There's three more to go. And everybody was so happy about the Connick, Don, what's his name? Connick. And then the other guy, forgot his name, starts with an L, Lucas or something. So he still has them that team out there. You think the prosecutors and the judge wanted to push her out, Nicole would have won the case. You really think that, PDQ? Do you think it's because of the Curcio, or because at first I did, okay, I lovable. I did think that. I thought, okay, oh my God, I don't think that they're really buying the fact that, you know what, okay, good evening, hon, lovable Leo. How are you? You got the Curcio sticking over your head, and you know, that conflict of interest thing probably would have kind of still been sticking in the back of the heads out there, because you have to realize that she still was working with the attorneys and things. So who's to say that? I mean, I don't know if I want to say that on the live, but I don't know. You say she knows her stuff, huh? Do you like the judge, PDQ? Do you like the judge? Let me finish reading this right quick and then we can get into it. The motion asks Donnelly to deny prosecutors attempt to add 15 new alleged victims to the case, which alleges a conspiracy by Kelly to use his music career to serve his own illegal sexual appetites. Let me read that one again, because you want they're making an allegation that he used his musical career to serve his own illegal sexual appetites. Really? Really, Messenger? Really? Okay. Because I mean, we can start singing a whole bunch of love songs from different artists. Really? But I get it. It's not about them. Given the nearness of the trial, the defense is not giving ample amount of time to ensure an adequate opportunity to assess the evidence, the purpose for which the evidence is offered, and whether prosecutors had the legal basis for their requests. Becker and attorney Thompson Farinella wrote in a 13-page motion late Friday. Kelly, 54, is scheduled to go on trial in Brooklyn August 9th on racketeering charges alleging he ran a criminal enterprise that recruited women and underage girls for illegal sexual contact, then isolated and threatened them to keep them under control. Well, I don't know about that, Mesnick. Them girls was not under no damn control, in case you didn't notice. The one that said she was trapped in the Sprinter on the inside, where all she had to do was unlock the door and get the hell out. That was it. So you should have threw that one in there, so that way you could try to change the narrative around a little bit, because ain't nobody ever trapped on the inside of a damn vehicle that has door locks on the inside of it, or child proof, safety proof on it. You could throw that part in there. The allegations in the indictment include dozens of acts involving 6 victims, identified only as Jane Doe's 1 through 6. Let me jump back in here because it's still a little bit more. You don't believe that she would be fair. It's not Mesnier. That's what the feds are trying to prove. I got to understand what you're saying. I might have missed it. We, the R. Kelly supporters, have the bump all of the witness, so they have to find new ones. I agree with that one. I agree. No more love songs. Everybody going to jail. She has been catering for the prosecutors from day one. And Nicole she's not from New York, right? She's from, where is she from? Is it Minnesota or something? She's not from there. So I know I was reading some, or maybe it was Bookham or something over there, and it was like, well, because she, she's from the different jurisdiction or something like that. So I don't know. It says the 55 page motion filed July 23rd, which we all know what that was, and everybody got into an uproar about all of the text messages that was listed on that paperwork, right? Um, One-sided text messages. Bring in addition evidence involving sexual abuse, hush payments, unlawful imprisonment, and other crimes dated back 30 years that are directly relevant to and inextricably intertwined with the evidence of the charged crimes. Among the new evidence, prosecutors want the juror to hear Kelly allegedly sexually abused a 17-year-old boy he met at a Chicago McDonald's in 2006. That is very easy, I guess, because McDonald's have cameras, and I believe that she's from Detroit, right? I knew it was somewhere. Thank you, Never. Cameras back in 2006. I guess he secretly arranged to marry 15-year-old phenomenal singer Aaliyah to shit himself. Now, shouldn't that be saying that Demetrius secretly arranged this escapade? Shouldn't it be saying that? Because Mesner, I I don't understand why he did not put allegedly. He's got all of these things in here as if they are factual. And so when I see a writer writes like this, I just don't condone their writing. I I don't care for it. Like, you're telling me you're to read this and just know for a fact. And that's what a lot of people just does out here. There's nothing here. Allegedly. And then he's also put out here to the public that that this is what Mr. Kelly's um, um, case is about. Aaliyah. How about just putting in that he is being charged allegedly with a bribery of doing, of a marriage. They always got to list her name in there. So, but then everybody says, you need to be more passive or empathy about, Aaliyah. But yet then you ain't correcting the right people. The media is steady using her name as well to shield himself from criminal charges after he allegedly got her pregnant. Well, there he goes with the allegedly. Where he sure put that in there, didn't he? He didn't want Aaliyah's mom to come after his ass. He hurried up and put that allegedly on that pregnancy thing. I agree with you, Galatians, right now. I agree. It's just because you got to see him on Twitter. Because he does. He just everything. He just be popping them. And then when you turn around, now you'll have all of the chaos supporters on Twitter. They just kind of be, tagging him back on some things or whatever, but this is insane. So this here brought, and he allegedly talked about bribing a Cook County Circuit Court clerk for information when he was under the investigation in 2019. She allows everything from the prosecutors in the case, but denied Kelly's everything. Yeah. The only thing I agree with her on is they were all women then and now. Yes, sir. Hey, sir, Miguel. Hello. Kelly's lawyer said in a response that the prosecutors blindsided them with the allegations about the sexual abuse of the boy, which was the first to involve a male victim, would have led to additional questions about the sexual orientation on the questionnaire that went out to potential jurors last month. The new allegations also contended the first boy, identified only as John Doe, introduced Kelly to a second. John Doe number one introduced Kelly to a second alleged John Doe number 2 teenage boy. Well, guess who should be in trouble? John Doe number 1. What the hell you do that for? Who in the hell was it? Why ain't nobody cussing out John Doe number 1? See, because if a John Doe number 1 went to introduce Kelly to a second boy, then that tells me that you didn't introduce the monster because you didn't see a monster. Wasn't nothing wrong with Kelly. You introduced Kelly to this John Doe number 2 allegedly because you saw a R&B artist, a celebrity. Oh, let me introduce you to John Boy number 2. Well, that's to me where the story should have kind of ended right there, with whom Kelly also allegedly had an improper sexual relationship. Somehow Meisner knows that for a fact, and he included that in his argument. Nobody's having a problem with it. They're actually sitting out here waiting on Meisner to drop them some more information. Okay. All right. Instead of should be out there saying, go away, Meisner, because you are dropping stuff that is biased right now and unethical to Mr. Robert Kelly on his behalf, and that's just not cool. He doesn't even know this whole story, and look how he wrote this up. John Doe number 1 introduced Kelly to a second teenage boy. Then God dang, if it ain't right, then go get John Doe number 1. Shouldn't never done. If it's a problem with them, because obviously they've made it a problem by saying that allegedly Kelly had an improper sexual relationship. And out of all of these articles, and 2 years and went by, so I can understand the pressure of what Nicole may be going through, because it's like when they probably are 5 steps ahead of this defense, something else will drop that's got to take them 1 step back, because now they got to go redraw up the defense plan. Okay, so now more investigation, more this, they got to go do more searching. If you ask me, in my opinion, you guys, and if I was Nicole, and after learning about the 55 pages that did drop, and most of it was text messages, one-sided and things like that, I think that I would have held my ground and kept the ball rolling on this one, because at some point now, she is an attorney. You guys says that she's a fighter. You guys say she's a big dog. You guys say that she comes with the fire, the smoke, and the water. When she see the smoke, she knows she go start the fire. She'll got the smoke, and when she ready to put that shit out, she'll put it out. That's how y'all talk. Y'all put her up on this pedestal. The way I see it is like you say she's a ex-prosecutor. Well, an ex-prosecutor should know how they gonna come. You feel what I'm saying? This shouldn't be catching her by surprise. One would ask yourself, if she was still in the prosecutor's shoes, is this something that she would have done? I'm just asking for a friend. And being a prosecutor, they play freaking chess. They dirty. This is what they do. You can't sit here and tell me that Nicole, just because she's joined the Mr. Robert Sylvester Kelly team, that she's now 100% clean. She come from the prosecution side. So she is one of the R. Kelly defense attorneys. Should already know how the hell they gonna work. So what you guys are telling me is a little bit opposite of what I'm thinking. Is she weak? Or is it bearing on her because those skills of being a prosecution is still sitting right there in the back of her head? And I think that we talked about this not too long ago on one of the lives. And I specifically asked that question. I don't know if you guys were moderators. You guys remember when I asked that question about, is it hard to come out of a prosecution's shoes to step over into the defense side? I remember asking that question. Everybody said, no, she can do it. She's been doing defense. But if you were a prosecutor, to my understanding, she has been a prosecutor for many, many years. You got to know the tactics that they're going to come with. You are aware of them. They sneaky, they dirty, they hold out. They're going to hit you with some last minute shit. Period. And that's just how I feel on that. And that's just my opinion about it. I truly hope that she don't fold. I hope that she do not go. I hope that she do stand her ground and come out and keep fighting these people based on what she should already know how they're going to fight. That's how I feel about it. What up, Lisa? What up, Lisa? Hey, Dom. Hey. There's always new information, Dom. Every time you turn around, it's something new. So it says here that the topic of the sexual orientation has become as controversial as politics. Kelly's attorneys wrote this topic would have been ripe for questioning in the juror questionnaire. There is no question that the other purpose for which government seeks to introduce evidence from the John Does is purely salacious and sensational reasons. The motion also stated that there were absolutely no physical proof nor circumstantial proof that the new allegations involving Aaliyah, identified in the indictment as Jane Doe number one, are true. Even if there was such evidence, she can't be questioned about it since she died in a plane crash nearly 20 years ago. Well, that party got as a fact. I'll give them that one. I'll stop for a second. So yes, PDQ, I think that she should stand her ground and stay firm on this one here, though. I really do. I do. So, but yeah, we talked about the Curcio, Dom, and we talked about that it was probably still lingering out there, with that decision of the conflict of interest thing. And who knows, you never know, the Greenberg still might be sliding some stuff in, you know what I'm saying. You never know. You never know. Yeah, the judges said Kelly wouldn't be able to appeal if he lost the case. Well, I didn't see that, Dom. I didn't see that on Pacer or anywhere. I'm like, you guys been getting y'all information from some real undercover stuff. The stuff y'all be putting, I don't see that. I do not see anything about the judge saying that it was, that he would have lost his case or something like that. But if you say so, then I guess it will have to roll with that. We'll roll with that until I see otherwise. So I'm not going to say that that's what it is for sure. Because like I say, I don't know. I know that they were in a Curcio, and I can see that on Pacer. I see everything on Pacer. I sure do. I see everything on there. I see everything that gets dropped on there like everybody else do out here. I just don't be sitting here all day to elaborate on quite a bit of stuff. But well, I'll wait and see what's to follow behind that at 11 o'clock. We'll be waiting. Everybody will be waiting on it, for real, for real. Therefore, the additional information the government seeks to introduce regarding Aaliyah is nothing more than a conjecture and an effort to further shape their narrative, the motion stated. Kelly's attorney also objected to prosecutors failing to identify the alleged new victims by name, which they say puts them at a disadvantage when it comes to adequately preparing cross-examinations of a witness. I was just thinking, you guys, just had a thought. Just had a quick thought. I just had a quick thought. If all of the allegations with all of these alleged women, females, whatever you guys want to go by calling them, I don't care. According to the docuseries, the Lifetime movie things, and listening and following subs and ops and the sector for Team Kells. I believe that everybody was saying that, even other bloggers, all of their stories are the same. Okay, I'll check it now. All of the stories are the same. All of the stories are the same. That's what everybody was saying, right? And I'm going to reread this one here. Kelly's attorneys also objected to prosecutors failing to identify the alleged new victims by name, which they say puts them at a disadvantage when it comes to adequately preparing cross-examination of witnesses. All of their stories are the same. All of their stories are the same, is what they say. I got to do my check mark of where I'm at so I don't lose it. I'm going to go run a check on Pacer. It's never said that I should go and look. So I'm going to put some music on. I'm going to go check it. If it's something new, then I will try to bring it up, you guys. All of the stories are the same before I leave. In hell, just keep throwing them the same damn questions. That's all. I'm like, if all of the stories are the same, most of the females, these alleged females, will pretty much take the stand with the same damn teary story, right? Oh, he locked me in the bed. Oh, he didn't feed me. Oh, I couldn't wear this. Well, how hard is it to cross-examine some shit? I mean, like, well, what did you wear? Were you naked? What, like, okay, what you had on sweats? Well, damn, you had clothes on. You know, sometimes I'm just being silly right now. I'll be right back. You guys hold it down in the chat room. Let me go and check some shit.
And me from the start, by the way you said, the way you wrote it for me, yeah. Man, I felt your energy. Wasn't used to being loved and treated differently, yeah. But something went wrong, those got crossed, and now we're on completely different pages. Let's go where we were, where no one gets hurt. You're trying to pick the pace up, we should take it slow. Baby, keep your focus, don't you make me change my mind. If you love me, baby, don't you switch up the vibe. Baby, don't you, baby, don't you, baby, don't you switch up the vibe. Baby, don't you, baby, don't you, baby, don't you switch up the vibe. When you take me on a trip, always up and down and back and forth in merry-go-round. I just wanna get it right, but when you go left, I'm stuck here feeling left behind. Cause something went wrong, the signals got crossed, and now we're going different directions. Let's go where we were, when no one gets hurt. Baby, keep it right there, don't you stress the flow. You're trying to pick the pace up, we should take it slow. Baby, keep your focus, don't you make me change my mind. If you love me, baby, don't you switch up the vibe. Baby, don't you, baby, don't you, baby, don't you switch up the vibe. Baby, don't you, baby, don't you, baby, don't you switch up the vibe. If you love me just like you say you do, don't kill the good vibe. If you kill him, you're gonna kill us too. Baby, keep it right there, don't you stress the flow. You're trying to pick the pace up, we should take it slow. Baby, keep your focus, don't you make me change my mind. If you love me, baby, don't you switch up the vibe. Baby, don't you, baby, don't you, baby, don't you switch up the vibe. Baby, don't you, baby, don't you, baby, don't you switch up the vibe.
All right, all right, all right, all right. Let me see if I can get y'all back in a second. Okay, we back, we back, we back. All right. I don't know if I can, should I put, do I put it on the screen or not? Do I just play it safe and read it to y'all? Think I need to just read it to y'all? Put a one in the chat, just read it to you guys. Huh? Mic check, mic check. What's it gonna be? What's it gonna be? Other than that, I'll just read it. Better yet, let me just read it to be on the safe side. How about that? So give me a second. Okay. I'm going to read it first. U.S. Department of Justice, United States Attorney, Eastern District of New York. Public eradicated version. Honorable Ann Donnelly, United States versus Robert Sylvester Kelly. Dear Judge Donnelly, the government respectfully submits this reply to the defendant's memorandum of law in opposition to the government's July 23rd, 2021 motion in Lyman to admit certain evidence and preclude other evidence and arguments at trial, hereinafter death op, for the reasons stated herein in the government original memorandum. The motion should be granted. Number one, evidence regarding victims' sexual behavior with anyone other than the defendant and others at its discretion should not be admitted. I'll repeat that. Number one, evidence regarding victims' sexual behavior with anyone other than the defendant and others at its discretion should not be admitted. The defendant's response to the government's motion, give me a second, you guys. I wanna be able to do this. Okay. So I want to try to get it up on the screen, and I will. The defendant's response to the government's motion to preclude cross-examination or the introduction of evidence regarding victims' sexual behavior with anyone other than the defendant or others at his discretion is nonsensical, makes no effort to comply with the requirements of the federal RIVIT 412 and contradicts the very reasons for the rule's existence. First, to be clear, the government does not seek to preclude or limit cross-examination or evidence regarding the victim's sexual interactions with the defendant or with others at the defendant's directions. See Def Op at 1, which was evidence regarding victim's sexual behavior with anyone other than the defendant and others at his direction should not be admitted. The government has failed to provide any justification for excluding evidence of the witness sexual conduct during the charge period, whether with the defendant or others. The government will elicit information from victims regarding sexual acts with the defendant and, where applicable, with others at the defendant's direction. The defendant may, of course, cross-examine the victims as to such testimony. This does not mean, however, that he may stray into areas barred by Rule 412, small a, United States versus Thompson. Oh, I'm going to look that one up. I'm going to look that case up. 178F sub 3D 86, 94 WDNY 2016. Indeed, proving cases involving sexual misconduct necessarily requires the government to introduce evidence of the sexual behavior underlying crimes charged in the indictment. If the introduction of that evidence opened the door to the introduction of the other sexual behavior, evidence rule 412A would serve no purpose. Second, while the defendant claims that his opposition is submitted per rule 412C1, noticing the intent of the defense to elicit certain relevant evidence. At 2, he fails to comply with that rule. Rule 412 requires that, number 1, if a party intends to offer evidence under Rule 412B, the party must A, file the motion that specifically describes the evidence and states the purpose for which it is being offered. B, do so at least 14 days before trial unless the court for good cause sets a different time. C, serve the motion on all parties. And D, notify the victim or, when appropriate, the victim's guardian or representative. Fed RIV 412C1 emphasized added, the defendant provides no such specific description. See Def Op at 2, indicating without any valid explanation that at this time, the defense cannot catalog specific facts we intend to elicit. Instead, the defendant simply asserts the unspecified evidence of unspecified victims, sexual predisposition, and behavior with others unrelated to the defendant is somehow relevant because some of the charges allege some form of coercing, and or forced on the defendant's part. Def Op at 1. By its term, however, Rule 412 applies to criminal proceedings involving alleged sexual misconduct, including those involving allegations of coercion or force. Fed RIV 412A, conclusory assertions that victims will purportedly open the door to such cross-examination and evidence in their direct testimony. Def Op at 2 do not negate or alter the requirements that the defendant comply with Rule 412. Indeed, the unspecified general evidence the defendant seeks to admit regarding victims' sexual histories is precisely the sort of evidence that Rule 412 was designed to preclude. As the Second Circuit has made clear, the very purpose of Rule 412 is to preclude defendants from arguing that because the victim previously consented to The rule also requires the court conduct an in-camera hearing before admitting evidence under this rule and give the victim and parties the right to attend and heard and to be heard and be heard. Have sex, her claims of coercion should not be believed. United States versus Riviera 799. That's another case that can be looked up to, look at some of the facts or equivalent of what they're stating in this here motion as well, you guys. So nor does the exclusion of such unspecified evidence violates the defendant's constitutional rights. Although a criminal defendant has a right to present his version of the facts to the jury so it may decide where the truth lies, it does not follow that a criminal defendant has, how do they call a defendant criminal if they have not had a completion of due process? Yeah, they just call it a pre-criminal defendant. Has a right to offer evidence that is irrelevant to the government's charges. That's in Thompson 178. Sup 3D at 91, internal quotation mark citations omitted, citing Washington versus Texas. Oh, I'm going to peep into some of these, you guys. 388 US 14 and 19, chapter 14 and 19, and that was back in 1967. Taylor versus Illinois, they used a piece of that law up in there from 1988. Evidence that a victim has engaged in sexual acts with others unrelated to the defendant does not make it more or less probable that the defendant used force or coercion to engage in sexual acts with any particular victim. That was in C.F. Taylor, 178, for sub 3D at 92. Whether the victims engage in acts or prostitution before or after their alleged encounters with the defendant would only prove other people may be guilty of similar offenses of recruiting, enticing, or causing those victims to engage in a commercial sex act. They're citing that from United States versus Albert. And his was done for the 8th Circuit Court here back in 2009. So they cited that as well. I want to kind of go back over this too, because all of these, what they have in here, they cited them and they put their evidence in here of where they cited these from to make their statements have some factual evidence weigh into their motion. So, nor has the defendant explained how a specific victim's sexual history is relevant to any alleged bias or credibility of that victim, while the confrontation clause guarantees a criminal defendant the right to cross-examine government witness at trial. United States versus Figueroa, and they cited his and from 2008. Trial judges nonetheless retain wide latitude insofar as the confrontation clause is concerned, okay, to impose reasonable limits on such cross-examination based on concerns about, among other things, harassment, prejudice, confusion of the issues, the witness safety, or interrogation that is repetitive or only marginally relevant. That comes from Delaware versus Van Ardenau back in 1986. So they cited something from him as from this case as well. In this way, The confrontation clause guarantees an opportunity for effective cross-examination, not cross-examination that is effective in whatever way and to whatever extent the defense might wish. That was from Delaware Fenster, 1985, emphasis in the original. Exclusive of cross-examination regarding relevant sexual acts does not violate a defendant's Sixth Amendment right to confront witnesses at a trial. Finding preclusions of cross-examination as to irrelevant prior acts of commercial sex did not violate defendant's confrontation clause right. Something to look up, you people. The confrontation clause rights. Okay, I have to remember. I have this, so I'm gonna print it out and do some highlighting myself. So, finding exclusions of cross-examination of victims' witness regarding prior acts of prostitution did not violate the confrontation clause because the evidence was irrelevant to the charge sexual misconduct. It is. I guess they're gonna make it is. Wow, okay. Okay. Finding evidence of acts of prostitution outside the indictment time period were irrelevant to the charge conduct, and therefore Rule 412 exclusion did not violate the confrontation clause. Any alleged unchastity of a victim has no relevance whatsoever to the victim's credibility as a witness. That was from Albert. 561 citation in brackets omitted. Okay, let's keep it going. The defendant has made no attempt to specify what purported sexual behavior or sexual predisposition he intends to elicit or cross-examine witness on, or coherently explain how such evidence is relevant. That one is a tough one. I don't know how can the defendant could come back and specifically address anything about the sexual behavior or the sexual predisposition when he is saying that he is not guilty. And if he's saying that he is not guilty, he wouldn't be able to come back with a response to this because he knows nothing of it. These women, as he stated, is not telling the truth about him. And he also stated that he did not do this shit. I mean, I'm going to throw that word in there. So it would be hard to respond to just that alone by himself, because if he does, then it would kind of lead to some admission of saying that he was knowledgeable about any type of sexual behavior or sexual predisposition. So that makes it kind of hard. It would make it hard for me and probably you guys to even fight this, but I'm glad that it does say that. It says that he has made no attempt, and he can't make an attempt if he doesn't know anything about the sexual behavior or the sexual predisposition of this alleged female. So indeed, he does not even specify which witnesses he intends to cross-examine. Well, maybe that's because I need to just keep reading now because it's getting deep, but man, you guys got them down as Jane Doe's. Jane Doe number 1, number 2, number 3. Who, if you give him the names, maybe he would know. But keep reading, Pap. Keep reading, Pap. In these circumstances, the government's motion should be granted. The government does not seek to admit evidence of religious beliefs or experience. Okay, so that is number 2. We know that what we just finished was all of the the details and their arguments based off of citing different arguments that had abruptly used in different cases out here since some of the years was what 88 and so on and so forth. So they cited some of theirs in their motions of, so that they can say, well, this is factual. We believe that this is so and so. It was used over here, and they won. It's something that I really didn't see much of that was written up with any of Greenberg's work. It is good to go and dig up some cases and stuff and cite some of the things if those cases were winning cases. It's a good strategy to use. So number 2 says that the government does not seek to admit evidence of a religious beliefs or experience. As the court is aware, the government moved to preclude the defendant from cross-examining witness number 1 regarding his religious beliefs or experience described in a book published by witness number 1 in 2011. I got to look at the chat room because I want to see y'all response on that one right there. So give me a second. I got to pull y'all back up. That's a second here. Oh, do y'all want me to get this up on the screen? I can see y'all now. First, I wasn't seeing y'all. Says let me see if I can get it up on the screen because I know with Zoom they just be straight tripping, y'all. Let me see. Hold on. Okay. Is that better, you guys? Is there, can I, moderators, is that better up on the screen? I need to know. I'll move on once I see you guys responding. Mic check, mic check, mic check. Mic, mic, mic. Is the mic on? Is the mic on? Is the mic on? You say zoom in. Okay. Better. I think I'm at 125. How's that? Okay. I was just circling. Oh Lord, my thing didn't move now. Okay. All right, let's go. This one right here says the government does not seek to admit evidence of religious beliefs or experience. And as the court is aware, the government because I stretched my screen out. I was just trying to point this one here out to you guys. Thank you, SW. Thanks, ladies. Thank you, guys. It says, as the court is aware, the government moved to preclude the defendant from cross-examining witness number one. The government moved to preclude the defendant from cross-examining witness number one regarding his religious beliefs or experiences described in a book published by witness number one in 2011. Who was that? Who was that? It says a guy. Who was it? Who was it, you guys? See motion at 5 through 8. In his opposition, the defendant has apparently misconstrued the government motion as one that seeks admission testimony from witness number one regarding his religious experiences in it. Let me see if I got to get this off. Hold on. Okay, there we go. Get that off of there. There you go, Harlem. Yes. Okay. All right. I'm just trying to wake y'all up now. Y'all got me up with y'all, and I'm dropping the paperwork on y'all now. Stay up, stay with me now. So it says, yeah, and that was him, 2011. In his opposition, the defendant has apparently misconstrued the government's motion as one that seeks admission of testimony from witness number one regarding his religious experience in the defendant sounding demonic. The government has no intentions of eliciting any such testimony. As a result, the defendant should be precluded from cross-examining witness number one regarding these matters for the reasons set forth that the government motions, from the government's motions. Okay, the defendant, number three. We're on number three, so we're right here, ladies. We're right here. The defendant should not be permitted to reference prior psychological histories. And that is blacking out. Number four is the defendant should be precluded from making legally irrelevant and prejudicial arguments regarding the parents of certain victims. Oh boy, so looks like that where were the parents might be out of the question, you guys. It might be out of the equation right now. I don't know. The government moved to preclude cross-examination and the introduction of the evidence or argument that the parents of any victims consented to the defendants having sex with those victims while they were underage. The defendant appears to concede that any such alleged consent is not defense to the charges. Instead, he argues that the conduct of the parent is allegedly seeking to profit from or extort the defendant is relevant because presumably the government intends to elicit testimony from the witnesses regarding a lack of access to their parents or the concern that the parents demonstrated the witness or actions that the parents made to connect to a child. The government does not intend to elicit from its witness any testimony regarding their parents, concerns for them, or actions the parents took connect with their children. The government will, however, elicit testimony regarding the defendant's efforts to monitor and otherwise limit Jane Doe number 5 communications with her parents. It's a little too late for that. Such testimony regarding the defendant's action does not render the conduct of any parent or a victim legally relevant to the charges at issue. As a result, the motion should be granted. Okay, moving on. Number 5, evidence regarding specific instances of the defendant's I got to get this thing to talk. Good conduct should be precluded. In opposing the government's motion to preclude the admission and evidence of prior instances of the defendant's good conduct, including awards and honors received in connection with his career as an entertainer, the defendant mischaracterizes the breadth of the government's motion. Contrary to the defendant's assertions, the government does not seek to preclude background testimony by the defendant. Wow. So they're saying that I guess they don't want to hear much about his career, his musical career. Nor does the government seek to preclude the defendant from offering evidence of the defendant's pertinent trait pursuant to Fed R. Ibid 404A2A. Instead, the government's motion relates to the manner in which such evidence may be admitted and seeks to preclude the admission of evidence regarding specific instances of the defendant's prior good conduct. And we know he has good conduct, specific prior good conduct, such as testimony or evidence regarding specific awards or honors received in the course of the defendant's career or employment, or specific acts of charity. Rule number 5, rule 405. You say she on the run. 405 specifically sets forth the manner in which a person's character or character trait, where admissible, may be proved, and limits the manner of proof to testimony about the person's reputation or by testimony in the form of an opinion. Rule 405B further makes clear that the evidence of relevant specific instances of a person's conduct may only be used to prove a person's character or character trait when the character or character trait is an essential element of a charge. Federal R. Ibid 405B. Put simply, the defendant character or character trait is not an essential element of any of the charged crimes. Hold on, one second. Sorry, you guys, I'm back. Okay, so let's do this one again. Specifically sets forth the manner in which a person, character, or character trait where admissible may be proved and limits the manner of proof to testimony about the person's reputation or by testimony in the form of an opinion. That's the Fed R. Ibid 405A. Rule 405B further makes clear that evidence of relevant specific instances of a person's conduct may only be used to prove a person's character or character trait when the character or the character trait is an essential element of a charge. Put simply, the defendant character or character trait is not an essential element of any of the charged crimes. As a result, the only permissible manner in which he may prove to pertinent character trait is pursuant to Rule 405A. By reputation or opinion testimony, not specific prior good acts. I want you to see United States versus Dahl. This one here was from the Second Court, 1997. They're citing this from this case here. Proof of the defendant's specific acts inadmissible under Rule 405B because character was not an element of any of a charged crime. Moreover, as the Second Court has made clear, a defendant cannot simply claim that specific good deeds should be admitted to disprove knowledge or intention, which are elements of most crimes, because to do so would make the exception of Rule 405B. Swallow the general Rule 405A. The proof of specific act is not allowed. It's United States versus Dahl. They cited him from Circuit Court of 1997 case file on that one. So the defendant's reliance on the United States versus Hands, the defendant's reliance on United States versus Hands, Second Court. This is court article case from 2000 is therefore in apposition, while affirming the conviction in hand. So in order to know what the conviction of hand was, you would have to pull this case file here, 230F3D56, to see what the conviction was about with the United States versus the hand, okay? They get to citing all of these case logs right here. Yeah, this is a lot of work. You got to go in there and read their case log to see exactly how they're opposing, how they're asserting this and applying it to work in their favor as part of their evidence to show that, well, this is what happened in this year. This is, they use this in this year. This should work. This is just not, or this is what it is. So this is what they're pushing. And I just didn't see Greenberg do a lot of this type of write up on here of citing anything. So when you get to citing quite a bit of stuff, you're showing just cause rule, so they're using this work. So we expect for it to work as well for us. So, and especially depending on how many times a hand or where it says United States versus hand has won, cases or stuff with using his annotation about the law of what they're speaking on in this here paragraph here. So number 6 is the evidence regarding Jane Doe 8. Subsequent employment is irrelevant. In his opposition, the defendant makes absolutely no showing that Jane Doe number 8 employment as an exotic dancer years after the defendant has sexual intercourse. But here she was 17 years old is at all relevant. That her subsequent employment is admissible for proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. Whoa. So they're not going to, according to this, they won't be able to show proof of Jane Doe number 8, and you all know who Jane Doe number 8 was. They will not be able to prove her type of employment, whether if she was a dancer prior to the rest, right? Okay, let's move on. Certain text messages by Jane Doe number 5 and relating to Jane Doe number 5 should be admitted. Well, let's see what they say. The defendant's blah, 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 mouth getting dry, brain getting dry. The defendant summarily asserts that from a plain reading of the text messages, the government seeks to admit the messages would open the door to the very same evidence that the government is attempting to preclude, and asks that the court allow the defense latitude in cross-examination to explore the many topics included in the text message, such as sexual behavior. So they will be able to talk about it. They're going to be able to bring this out as part of their evidence, but the defendant will not be able to address any of it in return on cross-examination. psychological issues, certain actions of witnesses' parents. In so saying, the government assumes that the defendant is referring to the text messages between Jane Doe number 5 and Jane Doe number 5's mother, and not other text messages that the government seeks to admit. Even if so, the defendant has not explained and cannot explain how those text messages open any door to cross-examination. Rather, the text messages show only that Jane Doe number 5 recounted to her mother nearly in real-time statements of the defendant, as Jane Doe number 5 will testify. The defendant suggests that prior consistent statements are admissible only to rebut a recent motive of fabrication and not simply to rehabilitate a witness. He is wrong. As an initial matter, he ignores the prior consentment statements are expressly permitted to rebut an express or implied charge that the declarant acted from a recent improper influence or motive. I'm so testifying. Moreover, the defendant neglects to mention that Rule 801D 1B was amended in 2014, expressly permitting prior consistent statements for the purpose of rehabilitation where a witness's credibility was attacked, adding that the prior consistent statements are admissible to rehabilitate the declarant's credibility as a witness when an attack on another ground. And therefore, the case law cited by the defendant all before the amendment is inapposite. The court should admit Jane Doe's number 5 electronic note. You guys are still with me? If you go ahead, put a yellow heart in the chat room if you guys are still with me. I know, right? Never. The government seeks to admit an electronic note written by Jane Doe number 5. On August 30th, 2018, that contains the defendant's statement to her. See motion at 34 and 35. Oh, I'm gonna have to go all the way back for that one. Jane Doe number 5 will testify regarding the circumstances of those statements on the note. As indicated in the motion, the defendant's statements are, as contained in the note, are highly probative of the defendant's commission of the forced labor offense as to Jane Doe number 5. The value of such highly probate evidence is not substantially outweighed by a danger of unfair prejudice. Indeed, it is direct evidence of the crime. See United States versus Curley. Noting that for evidence to be unfairly prejudiced under Rule 403, it must tend to have some adverse effect upon a defendant beyond intending to prove the fact or issue that justify its admission into evidence. The admission of certain newspaper article is warranted under Rule 803.16. Oh, let's see. Thank you, ladies, for letting me know you guys are still here. She can testify on stand and tell lies all day, but exactly, Lisa. So it says here that the admission of certain newspaper article is warranted under Rule 803.16. As clearly set forth in its motions, the government seeks to admit newspaper articles from 1994 for the following purposes: to show that, 1, the defendant performed in Macon, Georgia on August 30th, 1994, in Albany, Georgia on August 31st in 1994, and in Miami on August 31st, 1994. There is nothing circular or confusing about the intended use of such articles. Such evidence is relevant for the reasons stated in the government's motion and is admissible pursuant to federal IVIT 803.16 and 902.6. Yes, ma'am, Harlem. X says sealing. The government requests that the court permit the government to file both a seal and a ratified public version of this motion. The ratified version will redact certain content from publicly filed version of this motion that details medical and other private matters of certain witnesses. Privacy interests of third parties may be compelling reason justifying sealing. The conclusion for this reason set forth above in the government's July 23rd, 2021 memorandum, the government motions in Lyman should be granted. So there you have it, you guys, respectively submitted by Jacqueline M. Casoulas, acting United States Attorney, and it is signed, and there you go. Any questions about this here, you can call 718-254-7000, ask to speak to Nadia or Maria or Elizabeth if you need any corrections or anything to go inside of the new motion. So it's a lot, you guys. I just kind of want to briefly just go over, what was it, six of them. I'm going to do it pretty fast. So the first one you have that was submitted was the evidence regarding the victim's sexual behavior with anyone other than the defendant and others at his discretion should not be admitted. That's number one. And number two was the government does not seek to admit evidence of religious beliefs or experience. Number three was the defendant should not be permitted to reference prior psychological histories. So are they saying that he won't be able to speak on the fact that he hadn't suffered from dyslexia or things like that? Is that what they're saying there? But they blackened out that paragraph right there because it does talks about probably his health or their health state, so maybe that's why they kept that private. The defendant should be precluded, this is number 4, from making legally irrelevant and prejudicial arguments regarding the parents of certain victims, who won't be able to do that. That's number 4. Number 5 says that evidence regarding specific instances of the defendant's good conduct should be precluded. Okay, that's number 4, right? 5. Evidence regarding Jane Doe, number 8. Subsequent employment is irrelevant. We won't be able to probably cross-examine on Jane Doe, number 8, when she was 17 years old. They find that it is relevant, and probably the ops will find that it is not relevant. So it'll probably be another argument based on the fact with this. They've really given them a little wiggle room to argue, you guys. Certain text messages, number 7, certain text messages by Jane Doe, number 5, and relating to Jane Doe, number 5, should be admitted. So, and number 8 was the court should admit Jane Doe's number 5 electronic note. Okay. And number 9, the admission of the certain newspaper article is warranted under Rule 803.16. And number 10 is the sealing of it. And 11 was the conclusion. The reasons set forth above and in the government's July 23-21 memorandum, the government's motion in alignment should be granted. So we're gonna stop that. I'm going to come back to you guys because I am beat. That was a lot. That was a lot, you guys. I hope you guys enjoyed that. I shared that with you, and I don't mind, this stuff is not free, but I don't mind for our little group over here. We're all good. We're all good over here. So we'll wait and see what else is going to come out, or we could go over this. You say her victims to say anything. Yeah. Crazy, right? Right? Sounds like number 5 are preparing. That's why she doesn't want to cross-examine her victim. They left them very little wiggle room, you guys, very little wiggle room. But I still would wish that, they came in as a team. I think that they all should go out, or you're welcome, never trust. I think that they all should, you gotta just ride it out right now. Like, just seriously ride it out for a second. I have some of the alleged ladies up on the screen back there. Yeah, just write it out, Yeah, Lisa. Yeah, absolutely. Hey, Smiley. Yeah. Yes, Lord. What do they predict out here? 4 or 5 weeks of trial to be going on? That's a long, long, long time. These people are literally they literally dig, They dig, you guys. Like, oh boy. Then to leave a little room for cross-examination, that's crazy, right? That's crazy. So, but like I say, I understand. I hope that, she doesn't, I hope that she doesn't. I really don't, you know. 4 is good. Yeah, keep 4. Yeah, keep 4. Yeah. Yeah. I don't know. Anybody want to call in? If not, if you guys don't want to call in, I'm going to get on up out of here. My pleasure to share that with you guys. And I'm pretty sure it'll be shared on quite a few channels out here so that you guys can get different opinions about it. But what I don't see is enough wiggle room for them to do the type of cross-examination that they was hoping to do so, So, but you know what? Fights keep going. Just got to keep going. Got to keep going, pretty much. Everybody knew it was going to be pretty tough out there. So it's going to be tough. Yeah. Yeah. It was so many hands in this pot, so many people stirring up so much stuff, so many phone calls, so much stuff sent to the prosecutors, Drunken Larry, he had slammed them. And, and I know for a fact on that one, I saw, put allegedly paperwork with his name right by it. So, oh, you called? Hold on, girl. Let me see what number did you call? That's because I'm sitting here with the phone. Oh shit. Oh Lord, we at 28. Okay. Go on and call me, girl. Call me up. Call me if you need some. Oh, you're very welcome, Sir Miguel. You're very welcome. You're very welcome. You ain't called nothing. You ain't called the hotline. Call, what's that one that what's his name song? Call the hotline. Drop the number, y'all, so she can call. Never trust is who gonna call? Wait. Oh, Beauty, you ain't called. Call the phone. Call the hotline. The phone line is open. You can give your take on what we just went over tonight as far as the Janies and the Johnnies and all of that good stuff. What do you think about not being able to ask any questions pertaining to the anybody's sexual behavior? Believe up in number 1 or 2, it said that he didn't respond. There was no response to this. Well, how can you respond to something that you know nothing about? What do you think that his response should have been? How do you respond? You can't respond to something that you do not know anything about. I see you, girl. You could put NA, non-applicable. That don't apply to me. I don't know what you're talking about. So that's weird, right? But he'll fight it. I truly would love to see Nicole stay on board with their team of 4. They say she's got the juice. Then show the people what you got. It's a win, lose, or draw out here. And that's how you came into this fight, and under the presumption that she was the woman. I surely do hope that I'm gonna say this. I surely do hope that there is no entanglement about money. You just went through that with thank you, Boo. You just went through that with the sector out here. Just went through the entanglement with money with Anton and Bookham and cousin Levi. You just went through all of that. So I'm gonna hope that that's not the case. You're very welcome, Lady Diva. You're very welcome. That's not the case. And y'all better keep your fingers crossed on that. And when I say keep your fingers crossed on it, keep y'all fingers crossed on that one. And that's all I'm gonna say on that part right there, because yeah, keep your fingers crossed that nothing comes up, that there was no entanglement with funds, because as Greenberg did state on there, they can't fool directly, with the funds unless there is just payments coming in to pay for the attorney fees and stuff like that. So I really do. Hey, I saw those sisters giving a lot of shout out here. I did. I did. So I got some more stuff that I can drop and I want to play, but it is 11 o'clock. I don't know. I think we're in about an hour. How long we been on? I don't know. How long we been on? But I did have one that I kind of wanted to show. Let me see if I can find it. Hold on. Oh, no, not that one. Oh, that's boring. Okay, this is the one I wanted to show you guys. So give me a second. Let me find it. And then I am going to get my butt ready for bed. So give me a second. I'm gonna get it out. You say, listen out for Harlem call, please and thank you. I definitely will. It's 11. Yeah, we on the same time zone. We're on the same time zone. Hold on, let me get this out. Let me get this up, you guys. Check this out. 1 second. Be right back. Sit tight. Don't let the bed bugs bite. Oh my goodness. Oh, it's on Chrome. I'm a coming. Oh, I'm gonna have to type it in. Y'all doing okay though, right? Everybody's good. Okay, so this one was 4 days ago. Let's do a search. Okay, I got it. I got it.
Offenders. The courts.
City's top cop is calling out the justice system and blaming the courts for skyrocketing crime rates.
We are arresting the violent offenders. The courts are releasing these people back into the community. That over 90 people charged with murder have been released. That should be a headline in this city, and it's not. So be adversarial to the courts. Ask what the courts can do different, rather than release violent people back to these communities to create an environment of lawlessness.
It's sad that common sense is seen as refreshing. Meanwhile, a former Democratic senator from California becoming the latest victim of the nationwide spike in violent crime, Barbara Boxer, revealing she was attacked in broad daylight.
I tried to cross the street and get away, and he slammed me on the back and reached across me. He was behind me and grabbed my cell phone out of my hand. And I just said, how can you do this to a grandmother? I want to call my grandkids. Why are you doing this? He could care less, and got in the car and they sped away.
That's what's the old line, a conservative is a liberal mugged by reality, something like that. Geraldo, in Chicago alone, 90 accused killers have been let go by the courts. Is it possible to do like a class action suit of victims' families against the city? Because it seems like politicians are only scared of lawyers.
Well, I think it's an excellent idea. I think that it's impractical. First of all, Superintendent Brown's a great guy, but he is transferring all the responsibility to the courts and the prosecutors, and the police department, which is woefully undermanned, I think really has to step up. What you have there is the blood flowing in the streets. I mean, it's just there's 12 dead this weekend. There were 12 last weekend, 17 the weekend before that. You know, it's so much bigger than the 90 murderers who are released, although that is certainly part of the problem. You have a situation here where we are losing an entire generation of young black men, and nobody cares about it unless there's a white cop involved. It is horrific what's happening. This is the civil rights issue of our time. There's a ghetto civil war going on. Everybody's got guns. They're dealing the drugs. They're fighting over turf, and they're firing into crowds willy-nilly, as if that was a sign of macho. You shoot up a barbecue and you kill a 6-year-old. I think that the fact that this is not the front page story, coast to coast, it really, to me, it fills me with dismay.
I agree. I mean, we say that gun violence is a national problem, but policing is local. You can't have it both ways. To Geraldo's point, Dagan, it's a different kind of crime going on. So you see Barbara Boxer, she's 80. Not that there's honor among muggers and thieves and junkies, but generally they don't really go beat the crap out of old ladies. Now that's every day.
It is every day, and if you read the story after story, just whether it's in New York or San Francisco, that these perps have long rap sheets, and it's very clear, if you just read the newspaper, that they should have been thrown in jail years ago and stayed there. But because of this revolving door, whether it's from bail reform, whether it is left-wing liberal prosecutors, they are not kept in jail. If anybody's picked up here in New York just for simple assault, they're right back out on the street immediately. And this is it's a unique kind of evil and cowardice, attacking elderly people. But just really quickly, I want to point out I've mentioned this on the show before, but there were 2 elderly Asian women who were stabbed in San Francisco by a man named Patrick Thompson. And the knife was as long as the arm of one of these elderly Asian women. And the handle broke off, and the serrated knife was stuck inside of her. Where did he come from? He had a background including assault with a deadly weapon. And he actually was supposed to be in jail for life. And he was released on a mental health diversion.
There you go.
And now he is being prosecuted. But these people are everywhere, and nobody cares about the victims. They just don't give a damn.
But thank God we got that guy in the Viking hat.
Right.
You know, Jesse, do you think CNN and the Democrats would pay more attention if we pointed out that the criminals are probably not vaccinated?
Speaking of not vaccinated, Geraldo, I just have to fact check you on the last segment. 900% increase in COVID cases in the Rio Grande Valley sector. And in terms of testing, 8% positivity rate in the detainment facilities. Now, New York City closed down at 3%. This is 8%. So you were wrong. I'll expect an apology in the commercial break. Kim Foxx is the villain in Chicago. She is the DA. She has 700 lawyers under her tutelage. And she ran on this anti-cop de-incarcerate platform, and now it's working out. She doesn't sentence people. Pre-trial sentencing doesn't happen. No bail. Everybody gets out. Soros-funded Gutfeld, $2 million to her super PAC from George Soros. So people, you ask, why? Well, they voted for her. They voted for her. So at a certain point, you have to say, Chicago, I feel sorry for you, but you're putting people in office that are raising body counts. Police departments and district attorneys are supposed to work together. But if Soros keeps funding these radical DAs that won't work with police departments to keep people behind bars, you're going to see more Chicagos.
Yeah, it's funny. If you think about it, if the mayor of Chicago was an old white dude, wouldn't you be kind of suspect of whether or not he really cares about black people? That's what they would think, given the amount of casualties. These are black and brown bodies.
So this issue on the prosecutors doesn't get as much attention as the police issue, but it should. Because now, okay, they won't listen to us.
Right, of course.
Won't listen to us, but will they listen to the police chief? Because it's not just the one in Chicago, it's the one in D.C. as well.
Right.
And in St. Louis, and in Los Angeles. So you have all of that. The 1994 Republican wave was partly about crime and many other things as well, but that wasn't just in Congress. That was all across the country. So for local governments and state governments, so to your point, if you're electing these types of people, this is the kind of results you're going to get. But there could be an even bigger wave happening in 2022.
All right. Ahead.
Brief rebuttal. Under Title 42, people who are infected with the coronavirus are turned back at the border.
They got rid of Title 42, Geraldo.
No, not yet.
They got rid of it.
Not yet.
They're not even testing.
Not yet.
Get
Not
out
yet.
of here.
Not yet.
Hey, Sean Hannity, click here to subscribe to Fox News
So,
YouTube page
I just
and
wanted
catch our
to
hottest
share
interviews
that
and most
with
compelling
you
analysis.
guys.
You
Hold
will
on,
not
wait
get
a
it
minute. Let me
anywhere else.
Let me get this off. Okay, there we go. There we go. I am back. I had to share that. I had to share it. They was funny because you know he went on.
But things are going to get worse. If you look at the acceleration.
Okay, let's get rid of that. Let's get rid of that. Let's get rid of that. Let's get rid of that one. Let me close that out. I'm gonna keep that because I need to put that in my files. Let's bring this back. Ba, ba, ba. There you guys are. It was funny because you know he went on. Okay. So I just wanted to share that with you guys because the one guy, he goes on by saying with that, you know, Kim Fox, she's just letting everybody out. It's like, she forgot somebody, dude. Yeah, she forgot, you know, but I had to share that. And I also wanted you guys to hear how, you know, everybody is touching back on the coronavirus out here. I guess different names and all of that. You know how they do, switch up the game on everybody. And so again, ladies, thanks for showing up. Thanks for giving a thumbs up. I'm about to crash, you guys. I got to get up early in the morning. I appreciate you guys sitting with me. I appreciate showing you information that I am able to retrieve, and most of you guys are retrieving it as well for yourselves so that you can read it and understand it as well. What up, Sandra? You said this is your type of entertainment right here. I can listen to the issues like this being discussed. Thank you, girl. Thank you. That kind of information is needed. I just kind of want to, throw it out there about the little statement that they was making about Kim Fox, Geraldo. How old is Geraldo now, you guys? God, I remember his show. I haven't, it's been a while, but he's still around. Geraldo is still around. I got so much stuff in my phone. I'm so behind, but I plan on coming out, and popping it to you guys just so that we can stay engaged over here and keep it going. So, but I think I'm done for tonight. So I did laugh my butt off about Bookham. I don't know what his agenda is and all of the other stuff that's going on. That's just, I don't know all of their stories like that to be deep inside. I'm going to keep my fingers crossed about with Nicole, and I really hope that it's not something that was spilled about monies out here, I truly hope it's not that. I hope that if she does make her decision to exit from the case, I do hope that she makes it as humbly as possible, by, I don't think that I would agree with the one excuse that is out here that, that it's probably best because if they would lose the case based on Nicole's being his attorney, that there is no room to appeal anything. I don't know if I'll buy that. It's pending because he's got he's got 4 attorneys, right? And thank you, hon. Thank you. He's got 4 attorneys. Wouldn't you need all 4 signatures or something on that just because it was, I don't know. It seemed like that there has to be something that is agreed upon as a whole, not just with Nicole. Like, so it was this rule admitted to, was this submitted to his whole team, or was it just Nicole? Because what I'm getting, the feedback that I'm getting back is that if they go along with it and they lose the case and they can't appeal it. So I don't know. You have a good night too, Never. You have a good night too. So it's just weird. Shout out to you, Spire. You're always coming over and supporting me when I'm just so quiet over here. But thank you. Thank you. Thank you. You know, I'm in my little quiet little zone till I cut up a little bit. But over here, just keeping the ladies over here a little entertained. That's all. That's all. Hi, Shannon. So I don't know, you guys, but tomorrow will come and the real answer would be out there because it will be at, you know, on black and white. It'll be inked up and on the you know, probably on the pacer, just like it was with the Greenberg and Tom. You know, it would say that, you know, withdrawal. But what is it, 2.5 weeks or so? No, you know, I get it. That's things happens. I do get that part. Trust me, I do get that. But ooh, it's like, you know what? I'm gonna look at it like strategy. Maybe she's just using strategy, right? Maybe it's just strategy. It's just strategy. That's how I have to look at it. It's nothing but god darn strategy. So with that being said, I like to say good night to everybody. I will see you guys sooner than later. And I hope that you guys enjoyed today's commentary, our little vibe, our little open chat. I'm going to try to get you ladies to start calling in a little bit more and being a little bit more active in the channel. It's back smooth over here, just like how you got it, girl. We back. We back. I told you we was going to get it back. Now you're going to have to still let me have my Funky Fridays, right? You know I still need my Funky Fridays, so don't be doing that. Don't be doing that. Let me see something before I leave off. Hold on. Let me see something right quick. I'll play my outro on this one. Gotta play the outro. Give me a second, see if I can get it to play. Hold on.
Empty bottles of red wine laying on the floor from last night.
Peace up, y'all.
A little drunk.
Have a good night, you guys. I'll check in with you guys. Thanks for showing up. Don't forget to hit the like, the subscribe button. Get over. Make sure you got your subscription up on the One Papoose channel as well. Until then, you guys have a beautiful night. Bye-bye.
Maybe we should take it slow. I don't feel too comfortable jumping into something new right now. Yeah, I don't really know anymore how to feel something again. Think I'm just scared of falling. Don't wanna go all in. I don't really know anymore how to be more than your friend. Think I'm just scared of falling. Don't wanna go all in. Early mornings in your dome, I'll be sneaking at the door while the sun rises. Cause I ain't got the time, yeah. Can't tell another lie. And baby, I know you want more than this, but you know I can't afford your kiss, so I'm staying for the night. But then I gotta say goodbye, bye. Maybe we should take it slow. I don't feel too comfortable jumping into something new right now. I don't really know anymore how to feel something again. Think I'm just scared of falling. Don't wanna go all in. I don't really know anymore how to be more than your friend. Think I'm just scared of falling. Don't wanna go all in. Oh baby, I don't know. I think I'm scared of falling, and I really don't know how to feel again. I don't really know anymore how to feel something again. Think I'm just scared of falling. Don't wanna go all in. I don't really know anymore how to be more than your friend. Think I'm just scared of falling. Don't wanna go all in. Yeah, yeah. I think I'm scared of falling. Don't wanna go all in.
Good night, ladies.